And before I introduce today's speakers, I'd like to cover a few housekeeping rules. We have attendees from around the state joining us today, and so we ask that you mute your phones to help ensure that we may hear all the presentation without interruption or distraction. We also ask that you please do not put your phone on hold during the presentation, and doing these two things will help ensure that we may hear all the presentation without interruption or distraction. There will be time for questions and answers during the presentation. You'll notice that there is a chat box so that if you have a question, if you can type it in, and we'll ensure that it is asked and answered. If you are seeking continuing legal education credit with the Alabama State Bar, I would appreciate you completing the evaluation that was sent with the invitation to the webinar. And during the webinar, I'll provide you with a code to enter in the survey. This will help with requirements for the Alabama State Bar attendance to verify that you did attend the webinar. And again, last but not least, today's webinar is being recorded. And after the webinar, we will be posting it on the center's website. So I think that covers it. Again, if you are just now joining the webinar, please do not put your phone on hold, and please do not mute your phone. At the end of the webinar, a code will be provided for those attorneys who are seeking MCLE credit, and the code must be entered on the evaluation form you received with the link to the evaluation in the email with the login and dial-in instructions for today's webinar. And now at this time, I'd like to turn the webinar over to our panelists.
All right. Thank you, Eileen, and welcome everybody to our second webinar in Collaborative Law. My name is Brian Turner. I am here today with Stephen Baer, Clint Cook, and Francis Nolan. And our webinar today is going to be about the roles of the members of the team in the collaborative process. A quick refresher from last time, we did an overview on what collaborative practice is. And in summary, it's a voluntary, consensual, non-adversarial process involving a team of professionals that tries to help clients, and we focused last time and we'll be focusing as well today on matrimonial law issues, although collaborative is available in any area where the parties want to maintain a relationship or want to resolve their dispute in a confidential manner. But it's a process in which the team that is employed is helping the parties reach a tailored outcome to their specific situation, taking into consideration the parties' interests and needs as opposed to taking on a positional bargaining, traditional litigation type dispute resolution method. This process takes place through a series of choreographed conversations with the right professionals working with the parties at the right time. The process requires that the clients consent to the process with a full understanding that they're giving up certain rights to proceed through court, that if either of them choose to go to court, the process will end, and that they would have to start over from square one, likely without much of the work product that has been created or disseminated through the collaborative practice. To flesh out how that process works, we're going to talk about the roles of the various team members, and I'm going to start by asking Stephen Baer, who is speaking on behalf of the mental health professionals who work in this process with us. Steve, if you would please tell us, your role, and also how do you describe the roles of the other members of the collaborative team?
Well, the first part of my role is to provide a safe space for the client to process their emotions and their feelings about the divorce and what they're going through. And in the process of doing that, it allows me to begin to understand the dynamics that exist in the relationship, the dynamics that work well and that are effective, and those that do not work well and have contributed to the end of the relationship. And understanding those dynamics then helps guide me in helping the client through the collaborative process. But it also helps me then to be able to inform and educate the other members of the team about the dynamics between the couple that work and don't work.
Okay. And how would you describe, when you're meeting with the client for the first time, and they're asking you about your role in the collaborative process, how do you describe what the other team members are going to be doing in relation to the services you're providing as a coach in the process?
Well, I explained to them that the lawyers on the team are going to help with the legal aspects of the process, and that the financial neutral serves the role of helping them figure out how to economically support the family going forward in a way that ideally works for everybody.
Okay. And how does your role as a coach differ from your role as a clinician providing counseling services?
Well, it's shorter term work, first of all, and secondly, it's not focused on trying to change any of the client's issues. It's really focused on helping them manage their issues through the process.
Okay. And is there a role that, as a mental health professional, you play if the parties have questions about what's best for their children or how they should co-parent? How does that work with your role?
Yeah, it goes in a couple of different directions. Part of the task is developing a parenting plan. So, I'm gathering information about the children and what their needs are, and helping to weave that into the ultimate agreement, right? And if it becomes particularly complicated, or they have a child with special needs, then a child specialist can be called in who essentially serves as the voice of the child in the process with the rest of the team.
Okay, so the children may end up with their own voice through a mental health professional.
Correct.
To help shape how this is going to work.
Correct.
For the co-parenting plan moving forward.
That's right.
Okay. Quentin Cook, I'm going to ask you the same questions. How do you describe your role to clients, and how do you describe your interactions and the roles of other team members?
Well, first off, financial neutral is exactly that. I am the neutral. I am impartial. I do represent both of the individuals in the process. I facilitate the meetings, but most of all, I would classify myself as an educator, in that it's not unusual for one person in the process to be less financially sophisticated than the other, or more aware or less aware of the financial responsibilities of the household. So educating those individuals, going through budget analysis. But for the team, I identify the information that's needed financially. I gather that information. I organize it, analyze it in a way that can be simply presented to the rest of the team in the process, get that disseminated out. But one of the areas is that in traditional divorce setting or adversarial divorce, frequently the settlement is not analyzed to understand the ability to maintain a household. When you're splitting one household into two different lifestyles, that may have been sufficient for one dwelling or a family as a traditional family unit, how that's going to look for them, not only tomorrow, but next year, 5 years down the road, so that they can make the educated decision on the settlement proposal, that it is appropriate to their needs as well as fair to both individuals.
And do you find that that gives the party the opportunity to, for lack of a better term, try on different scenarios to see what they look like before entering them into an agreement that becomes a court order?
Absolutely. Because if we do find through the process that the financial resources are lopsided or not sufficient and overly sufficient, then I go back and work with the attorneys. Of course, I can't make settlement recommendations.
Sure.
But we do work together as a team to find out, what is going to be most suitable.
Now, you say you represent, as a neutral, you're representing or working with both parties. Do you meet with the parties individually?
Yes, that is a possibility, but when we do that, it's with the full understanding of all parties that meeting is taking place. It's not unusual at all, especially from the educational standpoint, for one person to understand what those expenses or potential settlement options may look like for them. But when we do meet with parties individually, after those meetings, the content of those meetings are fully disclosed to the entire team. There is no secrets. There are no secrets. Anything that is presented is available, and if anything is presented and has to be kept secret, then that could actually jeopardize the process as a whole.
Okay. I'm going to pass this along now to Francis Nolan, who's going to describe the differences in the role of an attorney in collaborative as opposed to a traditional litigated model, and also how you describe the roles of the team members to clients when they're sitting in your office.
Well, I think the most significant, probably for purposes of lawyers listening today, aspect to understand is that as an attorney working in a collaborative process, you are engaged to perform a limited scope representation. You have the right to unbundle your services under the rules of ethics and professional conduct, and you make that clear through the engagement that you establish with your client that your job is to assist in the settlement process, and you are not taking on the role of an advocate in the sense that you're building a case for your client against the other party. It is a legal process, so I think clients are very comforted by the presence of a lawyer at the table. They are aware that it's a legal process, even though it is a cordial and hopefully respectful process. It is often necessary for the lawyer to normalize their experience in terms of what does a legal process look like and how is this consistent or different with that. And it's also important for them to understand their rights and obligations under the law, even though that is not going to be dictating an outcome for them in this process.
Okay. And how do you describe, your interactions and the workings within the other team members with Quint and Steve?
I think one of the most important things that I point out to clients is that the mental health professionals in this role are not therapists. I think the boundary between therapy and coaching in this context is often confusing. I think that it is a therapeutic sort of relationship, but you're not pathologizing, you're not diagnosing, you're not treating, you're really assisting in facilitating smoother, more effective communication and movement towards an outcome that is better for both parties. the neutral role is critical. The financial neutral's role is critical, both as a facilitator of meetings often, simply because they're the only neutral in the room a lot of times, although sometimes we do have a neutral mental health professional. But I think that their role as a neutral is important in the sense that the person marshaling the financial information isn't taking sides. And so because we're approaching this from the perspective of everybody's got to hand over what's relevant to the decision-making process, and one pair of eyes is going to be on that to determine that it's accurate and to ascertain anything that's missing, then I think that neutral role is critical in establishing some trust and confidence by the client in the process.
Leads me to two thoughts. First, as an attorney who's worked in this field, I often find that both the mental health coaches and the financial neutral are educating me as much as they are my clients.
Yeah.
Do you find that to be the case?
Absolutely. I mean, there's certainly, I guess for me, I'm not an accountant. I'm not a financial advisor. The ability to sort of offload that piece of the work to somebody who actually knows what they're doing is incredibly helpful. And to have somebody with that skill set who can educate me and or my client about specific things that are relevant to the case is incredibly important. Likewise, lawyers don't have the training of mental health professionals. We don't have the skill set that mental health professionals often need in this situation to be able to navigate the prickly parts of our clients' communications. And sometimes we find ourselves in a position of getting sideways with our own client because our role is very different. We're advocating for their goals. We're advocating for an outcome that is in everyone's interest. We're not necessarily advocating from the point of view of, yes, client, you are always right. No, the other side is never right. Kind of that sort of model is not where we're at. And so sometimes clients, I don't guess I've ever had a collaborative case where I didn't have at least a moment with a client where they thought I was advocating for the other party. And so sometimes you need a coach to sort of help bring it all into perspective and to remind everybody what we're doing and where we are.
So when you started doing this work, how did it feel, because it is very different, the first time that you sent a client off to have a meeting with a coach or a meeting with financial neutral that you were not participating in? Because as we talked about at the beginning and as we talked about last time, the lawyers are not involved in every meeting.
No, it felt like I died and went to heaven. That's what it felt like.
So, I may be speaking, for myself more than others, but I often find that as a lawyer, we're a little bit of a control freak.
Yeah.
We traditionally look at it as we've said, we're building a case. This is our case.
Yeah.
This is our information. We marshal the information. So in your role as an attorney, you're ceding some of that role to other professionals.
Well, to professionals who are uniquely skilled to do that piece of the work that they're doing. I mean, it's hard to wear all those hats as a lawyer. It is a relief to be cast in a role that is consistent with your education and training, and only differs from your education and training in the sense that you're not building a case. You're not trying to gin up a fight. You're trying to de-escalate the conflict and help the parties stay focused on resolution. But I found it to be a relief. I thought it was logical, consistent with everything that I wanted my clients to have access to in making informed choices. I mean, let's face it, 95% of cases settle anyway. They're going to settle after 5 years of protracted litigation, or they might settle after, depositions and exchanges of paper that are duplicative and exhaustive in terms of time and money, but they're going to settle. Right. So how much more wonderful is it start from the beginning with that as your focus and goal?
Well, and you said that, talking about your role differing in collaborative practice from your role in litigation. I want to put out somewhat of a hypothetical, though, that I don't think we're going to flesh it out necessarily to conclusion, but a situation where, and this is kind of one that we put together, a client comes in post-divorce. That client has gone through the traditional method. They've got a settlement agreement. The settlement agreement sets forth custodial time, division of expenses related to the children, but an issue that the parties had not thoroughly vetted was the extracurricular expenses involved with their children. And in this case, there are multiple children, but one of them is involved in something that is extraordinarily expensive. Outside the normal, they play baseball, they take a guitar lesson, but they're involved in an extracurricular activity that takes a significant amount of time, a significant financial involvement that now post-divorce in those two households, as Clint was talking about, that those parties are finding that they may not necessarily be in an equal position to finance that, but because of the way their divorce came out, one party or the other's got final decision-making authority, and I'm looking over at Steve here on parenting plan issues, related to extracurricular activities, and they're kind of holding the other person's feet to the fire, and they're not talking. How would you approach an issue like that? How would you have handled it on the front end differently than,
And just to clarify, are we assuming that they're each on the hook for 50%?
We're going to assume, each are on the hook for 50% of those expenses.
Okay, so one person's making all the decisions, both parties are on the hook for 50% of the cost, and we have an exorbitant cost for one child?
One child
out of three.
We'll say 3, sure.
Okay, all right. Yeah, what you got,
Well,
financial guy?
Well, one of the things, when we go through and we're breaking down expenses, we actually break them down to what is the parental's expenses, what are the parents' individual expenses, but then we break down in detail the expenses related to the children.
And where do you get the information to do that?
Well, that's through the combined conversations and meetings with the clients, and if necessary, we will pull actual documentation related to those expenses, not just, the extracurricular activities, but school registrations, for, field trips, for summer camps,
School pictures,
school
uniforms,
pictures, so, health related, prescriptions, the list is rather extensive. But if we identify all of these, especially those that are the extracurricular ones, then we have a better grasp of what those are going to be today, and even the longevity of that. If it is an expense that's only going to exist for 3 years, there may be a difference, more of a pro rata breakdown in the settlement on how one of those high dollar expenses may be taking place, but the decision or the conversation may also lead to the financial ability to just continue it at all.
Well, and we're also going to be wondering what's the mindset of the child with regard to the activity.
Right.
Which is kind of where I was going to.
Yeah.
Does the child really want to do it, or is this just something mom or dad's promoting?
Well, and how do you deal with that, Steve, when you've got a parent who says, I think my kid is fantastic at this activity, and I think they really need to be pushed and they need to do it, and by God, spouse B just isn't picking up their slack.
Well, yeah, I mean, that's part of where I come in, and, I basically have to understand each of the people, the players involved, and talk to them and figure out whether, an example, Johnny is truly interested in continuing to do dressage and ride his $100,000 horse, or whether that's really mom's thing.
Mm-hmm.
And if it's really mom's thing, then I have to be able to talk to her and try to work all that out.
So and that ties back in, and I just popped a couple things up here on the screen about interest-based versus positional, negotiation, and how do you assist in that?
Well, in the beginning, by helping my client identify what their true interests are, and through the team process, try to match that up with those of the other person, and come to some kind of consensus that they both can agree to, that becomes the blueprint for going forward in terms of supporting the children. And
so we're digging past, that initial comment. He never, you can fill in the blank, while we were married. It's not fair for him to blank now, so he needs to pay for this. That's a position. That's the sort of like old school starting point frame of mind that you're going to dig down underneath and figure out, so what's really going on here? What is this really about?
what's it really about, right?
Yeah, because it's never really about the position. It's always about something else.
Right.
And Quint, in that situation, when it becomes a financial issue, you got your spreadsheets up on a screen for everybody to look at. How do you handle that position when people are entrenched in but this is what I want?
From the standpoint, at that standpoint, it's really almost kind of basic financial planning. You've got to categorize what's most important for you financially. Do you want to spend money on whether it's the extracurricular activity or if you want to spend money elsewhere? That's, if the funds just aren't available. But, educating both parties on what those repercussions are, and for them to have a full grasp of this decision that they're making, near term and long term.
Well, it's important, isn't it, to point out if there's a lack of parity between the parents' ability to contribute 50% to support something like that. I think in traditional litigation, we don't always look at what does it mean for the financially able party to be in a position of not being able to count on the other party.
Right.
What's the real benefit there? Do you want to spend the rest of your life in litigation? Do you want to continue to have to go after something that is not financially viable? It's really not a good option. They can't do it.
Well, it just takes them down the road of being positional.
Right.
It sends them back in the wrong direction, which is not the goal of collaborative.
Right.
I'm going to back up one statement on our screen here, and Quint, this one was one that you had mentioned to me in a difference in your role, and that is the statement about trust and verify versus distrust and prove. Can you explain the difference in your roles from that perspective if you're a hired gun expert in one case versus a financial neutral in a collaborative case?
If I'm the hired gun in a traditional divorce setting, I'm doing financial forensics. I'm looking to help the attorney build the case. I don't trust what the other party is doing. I am fully on board with one party. In the collaborative situation, in the collaborative process, a collaborative case, because of the written agreement that they are going to disclose, they're not going to hide. My position then becomes, I trust that everything is being provided to me. However, I will verify it. So I guess I'm not trusting 100%, but there are also things that people honestly, genuinely miss. If I ask anybody that's participating in this webinar, what are your expenses? What are the chances are that you're going to think of everything?
Right.
Where I can go through and say, well, what about the pest control, the termite bond, the Christmas presents? When your child goes to the other kid's birthday present, how many are you spending $20 to go to Johnny's best friend's birthday party, the gifts there?
And how about that case where they spend $10,000 a year at Starbucks?
Oh, yeah.
Yeah.
Well,
Well, and you and I had a case recently where we sat down with my client in a very similar situation and went line by line through her budget, and at the end of we've discovered neither party could live within their means with what they were discussing.
that's right. And both of them at the conclusion of that meeting said, you know what, we can move forward now with peace of mind that one person isn't winding up being much better off than I am, even though there was a disparity in the salary income, but the expenses and going through some of those as pro rata or 50-50 related to the kids balanced that out. They both went through and said, yes, we can sign the agreement now in good faith.
And I've just put up the statement that making sure that each party is heard and feels like she or he is being heard and understood. And Steve, I think that often that role falls back to you.
Right. Yeah, that comes back to me.
It sounds prettier and easier than it is, though, right?
That's right.
Yeah.
You know, and I think in the scenario we're talking about, you know, the hypothetical that we started with, we have one party who, you know, feels like the other's not listening to their financial concerns. And how do you step in and help these people step back and really, you know, come from a position of being their best selves when negotiating?
Well, part of it has to do with identifying their true interests and goals and separating that from being positional and usually being distressed and angry with their spouse, wanting to punish them, right? And
which isn't always easy to get them away from that position.
No, that's correct. And you know, I find myself frequently having to drag them back away from that spot to the goals and interests that we've agreed on in the beginning.
Right.
And get them recalibrated, refocused on those.
So, and I think that's an important thing to point out, that at the beginning of the process, typically we all sit down and say, what are your goals for this process? What is it you're trying to achieve here, so that we can come back and hold their feet to the fire and say, well, do you remember when we started? You said you wanted this to be fair financially to both of you.
Right. Well, and in addition, we put that on paper.
Right.
Ink on paper, and everybody has a copy of it, and it becomes the roadmap going forward. And we frequently have to refer back to that and pull people back to that agreed upon set of interests and goals.
Right. And one of the things I think that we've discussed as being attractive about collaborative is the confidentiality. And I think, Francis, you've often talked about we've created a safe space where we've created this protective bubble for this to happen. Can you talk a little bit more about your role in making sure that happens?
Yeah, I think, you know, to me, that's the critical piece of the team. I think people can often think that the team seems cumbersome, or that's a lot of people, you know, why do we need all those people? Well, you know, the creation of a safe container for people to go through what is arguably, for anyone, a very challenging and stressful process, to feel supported by mental health, lawyers, a financial person. It takes a minute to kind of cohere as a team and to get to know the parties and to understand their dynamic. But once you do, what you've done is you've empowered the parties to sit across a table and look eyeball to eyeball and have conversation with one another, instead of this caucus-style approach where nobody really knows what the other party said. They only know what the other party said through a translator.
Right, through the filter of their lawyer.
And there can often be distrust and misunderstanding created by that. So I think there's nothing better than having an environment where you sit down across the table from your spouse, even if it's hard. I mean, these are not always pretty conversations, but to feel like you're going to hit a bump in the road in your communication and there's going to be somebody there to help you navigate that.
Right. And you said at the outset, Francis, that, you know, what we're trying to do is help them reach their best outcome. how many times have you looked at a settlement as you're going through it with your client and go, this may not be what I would have advocated for, but through watching the process unfold, knowing that this is what's best for the clients.
Yeah, that is probably one of the hardest paradigm shifts for lawyers we're so outcome oriented as traditional advocates, and in the collaborative process, we really have to let go of that. The outcome is owned by the parties. The team members are not invested in outcome. They are supporting the parties to reach their own outcome. And that is really a very different role. And I think the only way we stay true to that is to start the process by helping the parties identify their goals and interests, and then keeping them refocused and constantly bring them back to that.
Go ahead, Clint.
We have seen time and time again where the divorce process destroys the family unit.
Right.
At the end of this, at the end of a divorce, the participants, they're still a family. It's a different look to the family, but especially when there's children involved at whatever age. And, this does follow, the collaborative process follows the idea or ideal that at the end of this, they can all still communicate, they can all still interact. It won't be like it was when the marriage was young, but it does try to accomplish the goal of keeping some level of similarity for the family members.
Right, and on my end, part of the focus is to help create a healthy co-parenting relationship with the parents.
So I think one takeaway, hopefully, that everybody listening can pick up on, as we're looking at some of the pitfalls, is that this is not easy. This is not touchy-feely. This is not let's all sing Kumbaya and hug.
Not hardly.
Not hardly. That this is actually very, very difficult. And from the standpoint, I think each of you has touched on roles, and Steve, we haven't really asked you about roles as an expert, in litigation, because that's really not a role you take on typically. But how do you guys find that all of you that with there being no fallback of, well, heck, we're just going to go to the judge? How do you keep working with parties when they come to these impasses?
It's all about the goals and the interests that have been established from the beginning.
From the get-go, right.
And if you don't have that, you're a sunk ship. I mean, all families are different. All dynamics are different. All post-divorce restructured families are different. It's not like this is going to be a panacea that ushers every collaborative divorced family into a perfect world without conflict. I mean, some people are just better at this than others. And, the people who are the most focused on really preserving that peace for their children, for example, are going to be more committed to it and more, successful.
I was about to say exactly that. The people who are able to focus on the needs of their children and make that more important than their own needs are the ones who are good candidates for collaborative. Folks who are more focused on themselves and or in punishing their soon-to-be ex and cannot get away from that, it doesn't work well for them.
So what do you do in the situation, and all three of you, when you run into one party who may not want the divorce or may be trying to keep things from going forward at a reasonable pace or just can't seem to get it together for their meetings? How do you handle that? Because we don't have a scheduling order. We don't have a judge saying you're going to show up in my courtroom on October the 10th. What did we do?
Well, from the financial side, there's always, always someone that is more educated than the other on the financial matters related to the home and the family. And that has a tendency to lock some individuals up, not knowing where to go forward. And that's where my standpoint in working with the mental health professionals, as well as the attorneys, to help keep the process moving forward. And in some of those meetings, there may be literally just one side of the party, their attorney and their mental health professional, to help them work through those issues. But at the same time, we are conscious of the fact that we're not pushing them in a manner that's going to put them in a difficult situation, or a situation that they didn't want to be in.
Or backfire.
Yeah.
Right.
So
Well, that said, one of the things that I try to do is establish time-framed goals moving forward in time, and try to hold the person accountable for doing their part of that work. And if they don't, then that becomes a different topic of conversation. How come you're not doing what we agreed that you're going to do? Let's figure out what's going on.
And that falls back to those notes and minutes that we talked about last time, and some today, that, well, here are the minutes from that last meeting where you said you would do A, B, and C, and here's how we're going to hold you accountable because you said you would do this.
Right.
Well, and we may have to refer them back to the participation agreement, where we establish the rules of engagement and the promises that the parties make to each other and to their lawyers with regard to the conduct that they will have during the case. But then that said, there are times when you do realize that one party is emotionally unable to move forward effectively, right?
Right.
And so sometimes you do have to slow down a minute.
Sure. Yeah.
And with that, I mean, because we always set the next meeting, we always leave with another meeting on the books and know where we're heading next. When you run into a client like that has an emotional issue or an anger issue, or just not wanting the divorce to proceed, how do you avoid, and I've got the big word up here, countertransference of the parties' issues amongst the teams? That's hard to not sit there.
That's a Steve question.
No, it's a Steve question, but this is one that I would say Steve has had to coach me on in the past as well. In the client's model of how they interact.
Right.
Well, one of the values of the whole team approach and the kind of the rules of the road of collaborative is that we're constantly communicating with each other about what has happened between each of us and the clients.
Right.
And so we have a feel for how each of us is reacting to each of the clients and the process. And, sometimes we have to sit down with each other and say, hey.
Yeah. We call each other out.
Call each other
That's
out.
part of being on the team.
Right.
Right. And whether it's, and it can be on the same side of the team versus you're not necessarily calling out the opposing coach or the opposing attorney, or, sometimes it's the financial neutral.
Yeah.
But it can be within your own side, like, hey, you need to step back a little bit. You're getting too wrapped up.
Right.
And very often, it's the fact that the clients just don't like the facts of what got them to the process to begin with. Their marriage is falling apart. We are dealing, obviously, with the most intimate aspects of people's lives: their homes, their financial security and well-being, their children, how they function as parents, their intimate relationships in many respects, how they're planning on moving forward, from this step going forward. And how do we, as a team, help clients trust one another when they're coming into this process usually pretty wounded? What steps can we take to help them with that?
Well, I think when people are in conflict, and certainly when they're under stress, they have, I think this is one of the things that I always tell clients is, the minute someone speaks the word divorce into the air, it's as if someone had come in with a high-powered Hoover vacuum cleaner and sucked all the trust out of the home, out of the relationship. And suddenly, everything that the other person does looks suspicious. So to have the eyes of the team on the interactions and on the dynamics of the relationship often helps us to help the clients to reframe what they see through this new negative, distrusting filter and say, wait a minute, that's not what I just heard. Like, let's talk about what you just heard, right, Steve? I mean,
Right,
it's like
right.
you have to help them hear through new ears and look through new eyes. Like, this isn't a stranger. This is still the same person you were married to.
Right. It's like helping them reality test.
Exactly. Yeah.
Sometimes it's quite frequent when we're pretty far down the road in case settlement option discussions, that if as the whole team is present and working with both parties, that there may be where we just say, okay, it's time, we need a timeout.
Yeah.
True.
And
Send each other a timeout.
Yes, and we go to different offices, and where maybe frequently it's the mental health professional and the attorney that go into those offices, and the neutral kind of wanders around in the middle as needed, gets called in as needed, but they discuss the fact that this whole process is emotional. Everybody understands, especially financial matters are very emotional.
Mm-hmm.
And sometimes people just need to be talked down a little bit off the ledge.
Right.
And then we return when ready back into the conference room and continue our discussions. It's every now and then we'll have a couple of those timeouts, those breakout sessions. We go as far as we feel like we can emotionally, and sometimes we need a second or a third meeting of that nature to get past some of the emotional issues. But when it comes down to the finances, if the neutral has done his or her job, trusted but also verified, the numbers are the numbers.
Facts are the facts.
Facts are the facts. They've been verified. We know where we are. And so if there is any lingering doubt, then all of that can be brought to light.
Right. And then we can help refocus the clients that, again, we didn't create the facts, but we verified the facts. And we verified the information, and we are trying to help you reach the best outcome for your family. And like you said, your family's reorganizing. Mm-hmm. And we're here. We can't undo. We can't create money where money doesn't exist. We can't, make the calendar have more days for you to have with your children. But we can help you reach that outcome. I know we, as the professionals who've been yammering away here for the last almost 50 minutes, have shared a lot of information. We would like to open up the floor, Eileen. If there are people who have questions, we'd be happy to hear those.
So at this time, we don't have any questions from our attendees. But if you do have a question, if you'll type it in the chat box, we'll be happy to have your question presented. We do have a few minutes left.
Sure.
Questions?
And while we're seeing if there are, I think the two quotes that we included on today's slides, the first one at the very beginning of the presentation from Gandhi, and this one here from Holkeri, point out, I think one of the key things that we tried to touch on today is that everybody coming into the collaborative process thinks they know the truth. I've yet to have a client who's come into my office to enter the collaborative process who doesn't come in and say, this is how it's going to turn out.
And I know what's fair.
And I know what's fair and what's right, exactly. And Quinn, I know you've heard that too, that this is the only financial outcome that could possibly. How often does that prove out to be the case?
Never. Haven't seen it yet.
And sometimes, I have seen it, but the problem is, if one person reaches it before the other person's even tested the waters to see what the options are, mm-hmm. It's not the kind of durable outcome you're trying to get to.
Yeah, that's right.
So when you have that client who comes in saying, I know it, this is fine, I've done, and they just sit back with their arms crossed, how do you help them get to the point of understanding this may be the truth, but your spouse needs to get to the point where they understand as well? How do you help them understand there may be more than one final truth here? That, truth is sometimes in the eye of the beholder.
Well, saying exactly that is a good start.
Yeah, I think I like to help people understand that because the trust has been sucked out of the relationship, you can't just start at the end. If you try to start at the end, you're just going to escalate the distrust. You're going to escalate the suspicion. Especially, it's my experience that the leavor is always the one with the answer pile. Here it is. I got it. We're done. This is fair. And the leavee is over here going, wait, you what? You want a divorce?
And now you're telling me what it's going to look like?
Yeah, I'm not even processing the D word, much less thinking about what my future is going to look like. And that alone can be a complete derailment of the opportunity to get to the outcome that the person has in mind. So I often tell people, you got to let it go. You just got to let go. If you start there, you're not gonna have the process you want. You're not gonna have the opportunity you want. You have to just let it go and start at the beginning and let the other person catch up. Because if you don't, you're gonna end up somewhere you don't want to be.
Right. Well, I was about to say, one of the things I find myself saying frequently to the client is the other party is way ahead of you on this, because they've obviously been thinking about this for a long time, and they've done a lot of research and homework, and you're just one step into it, and so you have to have time to catch up.
Right. And that's one thing I think I like very much about the collaborative process is we do have that opportunity for catch up to happen outside of you have the opportunity to catch up. However, we have a hearing next week, or we have a hearing next month. We can work with them to build that trust so that the outcome that they achieve, even if one of them said from the get-go, see, here it was, both of them trust it. And both of them find it fair, and both of them have a stake in it, in what this outcome is going to look like, and can feel that because they've shared all the pertinent information, that they've had the best information to make the best decision available to them, that they have reached the best outcome that they could achieve.
Right, and if they've been successful in going through that process, it's really helpful down the road when their circumstances change and they have to make modifications to the agreement.
Right.
Right.
Right. That they're coming in not from a point of immediate distrust that, okay, life happened. We saw on the models that Quint showed us where these speed bumps could happen. We hit one.
Right.
Panelists, we do have a few questions coming in.
Okay.
One question is there a list of professionals that we can access?
Yeah, I think on the Birmingham Collaborative Alliance website, and also on the International Academy of Collaborative Professionals website. It should have a state-by-state listing of collaborative professionals.
Both,
the next one.
Right, and both I was going to say, both of those websites are in the slide packet, and I think, Eileen, that slide packet is going to be available to the, right?
Right, Brian. With the invitation to the webinar today, the slides were sent out to members ahead of time, and that was a request from prior feedback from our previous session. So everyone should have a copy of those, and if you don't, just contact the center, and we'll make sure that you get those. And we have another question. It said, Dr. Blair has been talking about the client singular. Does the mental health professional work with both partners, or does each partner have their own mental health team member? And then a follow-on to that is the client, the couple, similar to couples counseling?
It can work either way. In my experience, it's the exception to the rule that the mental health professional sees both parties.
Right.
Alone.
Yeah.
Yeah.
Yeah, we've had single coach models where they meet with both parties together, but it's not really couples counseling.
No, it's not like that at all.
Mhm. Yeah, but in most cases, there's a coach for each party.
And again, the focus is on trying to identify and understand the dynamics that exist in the couple, the ones that work well and the ones that don't, and help them to understand that, and then craft skills for going forward that allow them to work together effectively as co-parents.
But you do meet with both parties. You have four-way meetings, both coaches and both parties. So you do
Right.
have contact with both parties. You just don't have one-on-one contact with both parties.
That's right.
Yeah.
Right.
Any other questions?
There are no further questions. Do you have any closing remarks you'd like to make?
We hope that everybody is, finding this information helpful in understanding this very different model of practice and dispute resolution, and we hope that everybody will be back next month for part 3.
Well, great. And panelists, I'd like to thank you, Francis, Brian, Quentin, Stephen, for helping us to understand the different roles of the team members in the collaborative practice, and also for the takeaways you've given us today. Our third session for the collaborative law webinar will be held on November 2nd, where you'll learn about the how-tos of collaborative law, and we hope you'll join us. Please remember to complete your program evaluation using the SurveyMonkey link sent with the invitation. The code to enter on the survey is 36104. That code again is 36104. And today's webinar has been recorded and will be posted on the Alabama Center for Dispute Resolution's website. We invite everyone to visit the center's website and Facebook page for more training opportunities. We are offering a series of free webinars in addition to the Collaborative Practice Law series. Our next free webinar is set for October 16th, where we'll learn about the hype of HIPAA and high tech with Samaria Dunson from the Dunson Group. We're also sponsoring some free lunch and learns as part of the ABA Mediation Week, and we invite you to visit our website for more information on those as well. And again, thank you, panelists, and thank you, everyone, for attending our webinar, and this will conclude the webinar. Thank you.
Thank you.
All right. Thank you.
Disconnect here from.
Yeah, just